specific performance is a remedy given by the court which is stated under Specific Relief Act 1950. It requires a party to perform his contractual obligations. It is only issued in places where non-monetary compensation doesn't exist. A general rule is that specific performance will not be ordered if the contract calls for actual performance. It is stated in the case of MMI Industries against Letsin Industries that specific performance has the power to request a contracting party to do what he has to do. Accordingly, a party cannot ask for specific performance if he himself breaks the promise and is not prepared to perform it. As stated in the Section 4 Clause B of Specific Relief Act, specific performance is given by ordering a party to do the act which he is required to do. Section 11 Clause 1 of the Specific Relief Act states that there are 4 situations when a contract may be specifically enforced. Specific performance will be granted if there are no standards to ascertain the damage. This applies to the sale of unique and one-of-kind items such as famous paintings. This can be supported with the case of Gun Realty against Nicholas. Specific performance was granted for sale and purchase of shares agreement because the shares were not available in the open market. In the case that we have chosen, the plaintiff submitted that Section 11 would be suitable for the court to grant specific performance.
Facts of the case. In the matter of Menara Hapseng's Berhad's proposed development project, a dispute has arisen concerning the subcontract between the plaintiff and the defendant, the plaintiff having engaged the defendant for the design, supply and installation of facade glass panels and aluminium, now seeks specific performance due to non-compliance with the agreed terms. The case originated from Menara Hapseng's Berhad's project proposal, with the plaintiff appointed as the main contractor. The defendant, acting as subcontractor, was tasked with the design, supply and installation of facade glass panels and aluminium for the proposed development consisting of 29-story office buildings and associated facilities. Therefore, from this case, the plaintiff and the defendant had made the understanding of establishing a subcontract to a letter of appointment on 24 January 2012, which obligated to perform both performance, which is the terms and conditions that has been understood and the Fenestra's performance specification and also the warranty. Notably, the Fenestra performance specifications emphasize the requirement of the glass to be free from any defects. However, in September 2016, it was discovered that the laminated facade glass in breach of these specifications, which had laminated with the presence of the bubbles. Pursuant to the tender clarification, the defendant is obligated to extend the workmanship warranty along a 10-year system, which is for the performance. Despite the warranty stipulated 4 years expiration, the laminated glass packet issues emerged in 2016, falling within the warranty period. Consequently, in light of the defendant's obligations under the subcontract, which what the plaintiff wants is, the plaintiff demands specific performance, which the plaintiff insists that the defendant promptly removes and reinstalls the affected glass panels in accordance with the agreed upon terms, which is the plaintiff requires the obligation of the plaintiff to fulfill the terms that they has met in their memorandum of understanding before entering into the subcontract. So I think that's all from me for the background of the case.
So moving on to the next part is the legal issue. There are a few issues that will be discussed in this part. As for the first part, we will be discussing on how the court to determine on the damages that the defendant is entitled to pay upon the plaintiff. As for the second issue, is that regarding the specific performance that the plaintiff applied for the defendant. As for the last issue is that regarding to the court to determine for a just amount of the special warranties damages that must be granted from the third parties to the plaintiff.
In the legal cycle of AMBIA Berhad and foremost prospects Berhad and ANOR, the court navigated legal procedures the independence of the expert evidence took center stage, demanding unbiased opinion influenced by the information. Notably, experts were permitted to tap into established knowledge, exemplified by Dr. Zhao's unchallenged method. The court flagged its authorities, awarding compensations and direct damage proof, highlighting its ability to assess damage and consider remedies like specific amounts. This power intended to enforce contrary duties, emphasizing the equitable roles of the court. The concept of greater surface is in a dispute with the stress of voluntary and international reputation. Additionally, the court will fit this discretion awarding substantial damages based on the inferior laws. When constitution proved challenging in summary, the case showcased the legal valid with the court employed with this principle, ensuring the nearest fair and precise solution.
Initially, the defendant breached the subcontract by failing to submit required special warranties for laminated glass panels as stipulated in the contract. Despite this, the defendant argued for a waiver, claiming the plaintiff abandoned corporate governance principles during a meeting on September 9, 2016. Witnesses from the meeting, however, confirmed the plaintiff never conveyed such a waiver. The defendant also argued that the plaintiff waived the requirement for special warranties by not objecting to warranty letters submitted for approval. The plaintiff did not insist on compliance with financial performance specification after receiving the letters. The defendant contended that the absence of insistence on special warranties before the issuance of the CPC amounted to a waiver by the plaintiff. However, there is no evidence of such a waiver, and the plaintiff had the option to postpone procuring the special warrants without hindering the issuance of the CPC. The defendant failed to promptly inform the plaintiff about warranties dated July 16, 2014 issued by a third party, demonstrating a delay in rectifying the breach concerning defective glass panels and obtaining the required special warranties. The presence of bubbles and delamination in 1,602 glass panels constitute a breach of product specification and ASTM C1172 requirements. This failure is considered a total failure to perform under the contract and a breach of the Sales of Goods Act, as the panels are unfit for their intended purpose. The third party raised a defense contending that it is not liable for the defects because the delamination was a result of the defendant's poor workmanship. The third party specifically pointed to the defendant's mishandling of the glass panel in storage, improper installation of the panels, and the design flaw in the whip holes as the cause of the delamination. However, the third party did not respond or counter defendant claim regarding the alleged poor workmanship. Mr. Singh suggested that the defendant improper storage of the glass panels in the flooded basement before installation may have allowed moisture to seep in, leading to delamination.
Lee Swee Seng Jae, the sole judge in this case, lined up his decision with a few pieces of legal reasoning. Generally, the case at hand involved a contractual dispute between the plaintiff and the defendant concerning the supply and installation of glass panels. So the court's decision encompasses intricate legal principles related to damages, specific performance, and general damages, offering a comprehensive analysis of the application of statutory provisions and relevant case law. So there are two main issues arise in this case, which is damages and specific performance. So on the issue of assessment of damages, the court begins by invoking the Selva Kumar anak lelaki Murugiah against Tiaga Rajah anak lelaki Retnasamy, where it emphasizing the principle that substantial damages may be awarded when quantifying actual damages is challenging but inherent damage is apparent. This principle aligned with the understanding that in cases where the evidence clearly shows some real loss inherently, the court may award substantial damages. So the court found that all these claims for damages come within the ambit of Section 74 of the Contract Act 1950, arising naturally out of the breach of the subcontract by the defendant. This section emphasizes that compensation should cover losses naturally arising from the breach or losses that the parties knew were likely to result from the breach. Next, for the main highlight of our remedy, which is the specific performance. So in this case, the plaintiff seeks specific performance, urging the court to enforce the replacement of defective glass panels by the defendant. The court meticulously examined Section 11(1)(b) and (c) of the Specific Relief Act 1950, which empower the court to grant specific performance when no standard for ascertaining actual damage exists or when pecuniary compensation would not provide adequate relief. The court has relied on cases like M. Red Navel against S. Lornadin and Interstate M against E. Sinamberhad against Foresight Trading Sinamberhad, underscoring that specific performance is an equitable remedy to enforce contractual obligations. The court deems specific performance appropriate where it's taking into account the willingness of both the defendant and a third party to honor warranties. This decision is supported by the rationale that it could potentially result in cost savings for all parties involved. So another damages that plaintiff has claimed against the defendant are general damages and special warranty damages. However, the plaintiff withdraws the claim for special damages, opting for general damages. In line with Section 74 of the Contract Act 1950, this section entitles the party suffering from a breach to compensation for losses naturally arising from the breach. The court, in assessing these damages, takes into consideration various elements, including the cost of engaging an investigator, the cost of replacing defective glass panels, workmanship costs, gondola usage, and overhead and supervision costs. So, in considering the third party's warranties, the court determines a fair and reasonable value for these warranties. The calculation involves a percentage of the contract price paid by the defendant to the third party. The court establishes conditions for payment and the retention of funds until the expiry of the special warranties. So, in conclusion, the court decides in favor of the plaintiff, ordering a specific performance and awarding general damages. The judgment provides a detailed and nuanced analyzing of damages, specific performance and general damages, grounding its decision in statutory provisions and pertinent case law.
To sum up, in this case, specific performance was granted for the third party's replacement of the glass and warranty under Sections 11, Subsection 1, Subsection B, and Subsection C of the Specific Relief Act. General damages were also granted in exchange for special damages, as specified in Section 74 of the Contract Act, and the defendant was granted the Marifa injunction. The court also held that by cost, the defendant had to pay a sum of 250,000 to the plaintiff, meanwhile a sum of 200,000 paid by the third party to the defendant.
Thank you, sir.
Terima kasih.